Thank you, Mr. President. I propose the following amendment. I'm sure this is just a case of oversight on the drafter. Page 5, line 7. And this refers to the issuance of subpoena. And I assume that this is a form of an administrative subpoena pertaining only to the investigative, to the particular mandate of this new body being proposed to be created, and I refer to the Professional Regulatory Board of Food Technology. So the idea here is to vest in that body the power to issue subpoena, and it is one of the examples of an administrative subpoena. I have no quarrel with that. It's just that it has to be made clear that this is a form of administrative subpoena, but while not being explicitly reflected in the bill. So my proposed amendment pertains only to the incompleteness of the usage of the word or the term subpoena duces tecum. The idea is to secure the appearance of witnesses and the production of documents in connection therewith. So if that is the case, then we need to insert the word subpoena ad testificandum and subpoena duces tecum, in addition to subpoena duces tecum, or just subpoena. So I propose line 7, and for this knowledge of the board and for this purpose, to issue subpoena ad testificandum and subpoena duces tecum.
The committee accepts the proposed amendment, Mr. President.
Any objection? Hearing none, motion is approved.
That's all, Mr. President. Thank you.
Majority Leader.
I move that we close the period of individual amendments, Mr. President.
Any objection? There being none, period is so closed.
I move to approve on second reading Senate Bill 1269 under Committee Report number 15.
Any objection? There being none, Senate Bill number 1269 under Committee Report number 15 is approved on second reading.
Move to suspend consideration of Senate Bill 1269 under Committee Report number 15, Mr. President.
Any objection? There being none, the Senate Bill number 1269, consideration thereof is hereby suspended.
Mr. President, with the permission of the body, I move to resume consideration of Senate Bill 1239 under Committee Report number 10.
Any objection? There being none, motion is approved.
Mr. President, this is the measure strengthening the PNP Criminal Investigation Unit. The parliamentary status of the measure is that we are in the period of interpellation. So may I move to recognize the sponsor, Chairman of the Committee on Public Order and Dangerous Drugs, Senator Panfilo Lacson, and to interpellate Senator Laila De Lima.
Senators Lacson and De Lima are hereby recognized for interpellation.
Thank you, Mr. President. Will the distinguished gentleman from Cavite yield to several questions, actually several set of questions?
Willingly, to the distinguished lady from Iriga and in the Bicol region and the Republic of the Philippines.
Thank you. My first question is the sponsor, is the good sponsor clear or certain in its understanding that under the current law or laws affecting the Philippine National Police, and I am basically referring to Republic Act 6975 and Republic Act 8551. 6975 is the DILG Act of 1990, and 8551 is the Philippine National Police Reform and Reorganization Act of 1998. Is it the belief or the position of the good sponsor that under these current laws, none of the officers or units within the PNP is vested with subpoena powers?
Certainly.
Not even the chief of police.
Certainly,
I'm
Mr.
sorry,
President.
the PNP chief.
Certainly, Mr. President, and that's the reason why we're amending Section 35B, subparagraph 4 of Republic Act 6975 to reinstate the provision under RA 5750, reinstating the subpoena powers of the CIDG director and the deputy chief of the CIDG, which was mentioned in 6975 as CIU, but it has already evolved into CIDG, Mr. President.
And therefore, the proposed bill seeks to reinstate the subpoena powers of the PNP through the mentioned officers,
That is correct, Mr. President.
director and deputy director of the CIDG, formerly CIU. So, the good sponsor therefore do not subscribe to any position or opinion that in fact the chief PNP has the power to issue subpoena, and that he cannot just delegate that power without an express grant from a statute.
Under the law, under 6975 and 8551, amending 6975, the chief PNP has no power to issue subpoena and subpoena duces tecum, Mr. President.
Is the good sponsor aware of Presidential Decree number 765, circa 1975, and therefore a later issuance than the Republic Act 5750, which gives to the chief and deputy chief of the CIS sub-subpoena powers?
I suppose the distinguished lady was referring to the PCINP.
Yes.
And the PCINP has been dissolved by virtue of the passage of 6975.
Yes.
Where the members of the Philippine Constabulary, the defunct Philippine Constabulary, were absorbed into the new organization known as the Philippine National Police.
And therefore, is it the position of the good sponsor that even if there was such an absorption of the original organization or the original institution into the new PNP now by virtue of Republic Act 6795, or I'm sorry, 6975, the power then vested to the chief PNP under the presidential decree is not necessarily absorbed also by the PNP chief.
This representation would like to believe that it was an oversight. When the law creating the PNP was passed, I think it was an oversight on the part of the Congress at the time, and even Malacanang when it approved the bill and passed it into law, that the subpoena powers of the director CIS at the time and the deputy commander CIS and deputy commander of the CIS were enjoying subpoena powers.
And therefore, the position of a good sponsor is that it was also a case of oversight that in the enactment or in the passage of Republic Act 6975, the powers of the chief PNP under PD number 765 has also been overlooked.
Yes, Mr. President. Senator Drilon, during his interpellation, before we went on December break, also manifested that the Chief PNP should also be given subpoena power, since he is the Director General of the PNP, and it might be awkward for some subalterns in the organization to be given the subpoena powers when the Director General does not have that power.
And I take it that the good sponsor is receptive to the proposal of Senator Drilon.
Very much so, Mr. President.
Can the good sponsor tell us what exactly are the powers of the CIDG now which necessitate the grant of subpoena powers?
The CIDG is the primary investigating unit of the Philippine National Police, but being the principal or primary investigating unit, the director of CIDG does not enjoy the subpoena powers granted earlier to the commanding officer or commanding general of the CIS. But they are mandated under the PNP law, to investigate cases brought before its attention, criminal cases for that matter, Mr. President.
And when the good sponsor says criminal cases brought to the attention of the CIDG, he is necessarily referring to the powers vested in the CIDG according to Republic Act 6975.
That is correct, Mr. President.
And necessarily, in proposing to vest subpoena powers in the CIDG, such exercise of subpoena powers, if at all that it is given to it, would be understood to be confined only to those cases falling within the investigatory jurisdiction of the CIDG.
It goes without saying, Mr. President.
So there is no need, it is the position of the good sponsor, that there would be no need to expressly say that in the proposed amendment via the subject bill.
If it is not so indicated in the law, in the amendment, then the director CIDG as well as the deputy director will not be given the subpoena powers. Mm-hmm. That's the reason why we want to amend the provision of 35B subparagraph 4, because it's just a simple enumeration of the operating units of the PNP.
But 6975,
yes.
May I interject? 6975 actually enumerates the cases falling within or under the investigative jurisdiction of the CIDG. Is that correct?
That is correct, Mr. President.
And therefore, any subpoena powers that are to be granted to the CIDG must be understood to be confined only
to the cases to be handled by the CIDG. Is that your point, Mr. President?
Yes. And does this good sponsor agree with the proposition that not all kinds of cases, criminal cases, fall under the investigative jurisdiction of the CIDG by virtue, again, of Republic Act 6975?
That is correct, Mr. President.
Because in fact, 6975 limits the investigative jurisdiction of the CIU, now the CIDG, to the monitoring, investigation, and prosecution of all crimes involving economic sabotage and other crimes of such magnitude and extent as to indicate their commission by highly placed or professional criminal syndicates and organizations, meaning syndicated crimes and economic sabotage. That is correct.
Going further, the unit shall likewise investigate all major cases involving violations of the revised penal code and operate against organized crime groups unless the President assigns the case exclusively to the National Bureau of Investigation, Mr. President.
So in which case, the CIDG can investigate any and all violations of the revised penal code.
That is correct, Mr. President.
Although under the current state of law, and I'm referring to the recently passed NBI modernization law, there are questions now here about which investigative body would have primary jurisdiction, because once a particular investigative body assumes primary jurisdiction over any of the cases enumerated in the law, then the other investigative agencies would just have to do their part in a supporting role or capacity.
Yes,
That is
Mr.
correct?
President, that's clearly settled in the passage of the new law modernizing the NBI.
Mr. President, I have to dwell on these preliminary matters because what we are dealing with here is the possible grant of what I call the general type of subpoena. And when we say the general type of subpoena, it is broad in character. It is a broad subpoena distinguished from the so-called administrative subpoenas.
We are only granting the director, CIDG, and the deputy director to issue administrative subpoena, Mr. President.
And
They're not
when,
being
and
granted-
when the good sponsor mentions administrative subpoena, what exactly is that for
Well,
the enlightenment
The
of the
director
public?
has no power to cite in contempt persons who will not adhere or comply with the subpoena issued by the director CIDG, Mr. President. He will have to refer the matter to the RTC to file a petition or a motion to cite in contempt persons who violate the issuances of the director CIDG, Mr. President.
I'm glad that the good sponsor has clarified that, because that was my next question, whether that is contemplated in case of non-compliance or disobedience to the subpoena to be issued either of the chief PNP or the director or deputy director of CIDG. Is there a contemplated consequence or penalty?
It will be exactly the same power granted to several or various government agencies and instrumentalities such as the Ombudsman, the Department of Justice, the National Bureau of Investigation, the Philippine Drug Enforcement Agency, National Police Commission, Bureau of Internal Revenue, and the Cybercrime Operations Center of the Cybercrime Investigation Coordination Center, Mr. President.
And meaning that, as the good sponsor has stated earlier, in case of disobedience or non-compliance, there would be no direct power, direct authority of CIDG or PNP to hold the person in contempt.
Absolutely none, Mr. President.
It has to go through the judicial process.
Yes, Mr. President.
Going back to the intended grant of subpoena powers to the chief PNP himself, is it also clear to us that such grant of subpoena powers to the chief PNP or the Director General of the PNP would only be just confined again to the investigative mandate or jurisdiction of the CIDG and not of any other units under the PNP?
That is correct, Mr. President.
And therefore, at a proper time, in the course of the period of amendments, when the good sponsor would introduce, I guess it would be now a case of a committee amendment, the power, the subpoena powers to be given likewise
To the
to the
Director
Chief
General,
PNP or
yeah.
Director
Will
General.
be limited to cases being handled by the CIDG.
Okay, thank you for the clarification. Next point. As I mentioned earlier, this is a case of a general subpoena or a broad subpoena. And I think the good sponsor would agree with me that at times subpoenas can potentially be broader than search warrants. And hence the potential for invasion of rights and also of some mischief is there, would even be greater than the power to apply for search warrants. Would the good sponsor agree with that
Yes.
proposition?
Mr. President, absolutely.
And because certainly A subpoena would have a greater reach because it would ordinarily describe just broad categories of documents or other property and is effective to reach any such items in the custody or control of the subpoenaed party, no matter where the subpoenaed items are located. Unlike in the case of search warrant, it is limited. There's the element or the requirement of specificity.
Yes.
It should be in the very premises as specifically described in the search warrant,
Otherwise, it will be an illegal
an illegal search warrant.
search warrant by virtue of its being a general warrant.
Given that premise, that in fact subpoena can even be broader, and therefore the opportunity for abuse is even higher or greater than the search warrant powers, can the good sponsor please enlighten us what specific safeguards, are there standards that are again, or that are contemplated in terms of limiting opportunities for abuse?
The safeguards can be found or may be found on, under GR number L29274. This is an old Supreme Court ruling, old jurisprudence, but I believe it's still the leading case, Mr. President. It's Pargo, Presidential Agency on Reforms and Government Operations versus Honorable Hilarion Arencio as presiding judge. The Supreme Court cited Section 71 and 580 of the revised administrative procedure. This is very old, Mr. President, 1917, but it finds its progeny in Executive Order 292, the very recent administrative code, Section 37, to be specific, Mr. President. And I would like to quote Section 37 of EO 292 in relation to Section 71 or Section 580. No, Section 71 and Section 580. Power incidental to taking of testimony. When authority to take testimony or receive evidence is conferred upon any administrative officer or any non-judicial person, committee, or body, such authority shall be, cannot read my own handwriting, Mr. President, include the power to administer oaths, summon witnesses, and require the production of documents by a subpoena duces tecum. And in the same Supreme Court ruling, Mr. President, the Supreme Court at the time mentioned or stated that they are mindful that the privilege against self-incrimination extends in administrative investigations generally in scope similar to adversary proceedings. So there are limitations or restrictions to the grant of the subpoena powers to administrative agencies like the CIDG, Mr. President.
Would a good sponsor agree that one of such limitations actually appear in the rules of court as applicable not only to the court-issued subpoena or the judicial subpoena, but also other subpoenas issued by any officer or body authorized by law to do so in connection with the investigations conducted? And this subpoena powers intended to be given to the CIDG precisely falls under that. That this is one type of subpoena, although to be issued by another officer or body, not the court, but to be authorized by this law, by this bill, if it becomes a law, and therefore would be covered also by the limitations set forth in the rules of court, and primarily the requirement of prima facie relevance.
Yes, Mr. President.
Do we understand this correctly?
Yes, Mr. President. Also, the same ruling, Pargo versus Honorable Harencio. It stated, may I quote this part of the ruling? In sum, it may be stated that a subpoena meets the requirements for enforcement if the inquiry is one, within the authority of the agency, 2, the demand is not too indefinite, and 3, the information is reasonably relevant.
Because precisely, again, in terms of protecting rights, private rights, it is important that law enforcers would not be overzealous. Because overzealousness, as pointed out, I think in your sponsorship speech,
Yes.
is actually the source of certain evils in terms of possible abuse in the law, in the execution of the law.
That's why the delimitations are clearly defined under this bill, Mr. President.
But pardon me, pardon this representation, if that is the case, can the good sponsor please point to us specifically which part of the proposed bill can we rely on in terms of those followed? And the idea, I think, is because it is understood that it should conform to existing legal standards. But I think it would be best if in our enactments henceforth, especially this kind of piece of legislation empowering the law enforcement, the law enforcers, we should be clear about that. And that brings me to the next question. Standards like prima facie relevance, these are normally not appreciated by non-lawyers.
If only to give due regard to the sign of the times, I agree with the distinguished lady, Mr. President.
And I think that is one of the reservation that is engendered in the minds of some about the very wisdom behind the proposal of the good sponsor to grant subpoena powers to CIDG. I know that this is being limited only to the level of the chief PNP, the director, and the deputy director of the CIDG. And it's good that the good sponsor did not consider the grant of subpoena powers lower to those lower in rank, like all the way to regional directors. Unlike the NBI, the grant of subpoena powers was, it's in the law itself.
Delegated
The
to regional
director, the
directors.
NBI director, the deputy director, all the way to the regional director. Although there is a reason for that, there is a justification for that, because regional directors and deputy directors and directors of the NBI are required to be with legal.
They're lawyers.
They are required to be lawyers. Is that the same in the PNP?
Not all regional directors, even the director of CIDG, not everybody who became or held, not everybody who held the positions of the position of director CIDG are lawyers, Mr. President.
Not even the chief
So we
PNP
should-
is required to be a lawyer.
Not even the chief
The
PNP.
director of the CIDG or the deputy director, are they required to be lawyers?
Preferably a lawyer, but not necessarily a lawyer, Mr. President.
So that makes it more imperative for us to be very clear
I
in the
cannot but
specific
agree.
standards to be followed in the grant of the subpoena powers
I agree,
to
Mr.
this
President.
set of officers.
In fact, Senator Dillon also inquired, also asked the same question, if the sponsor would be amenable to delegating or give the same powers to regional directors, and I answered in the negative, Mr. President.
Up to the regional directors.
No, I'm not for it, Mr. President.
Next question, is there a system in place for the proper storage or destruction of documents collected through this subpoena power?
The documents should be deposited to the courts, Mr. President. If and when cases are filed, then the document should be, and other pieces of evidence should be deposited. The legal custodian should be the court. But there are physical custodians assigned by the court to store whatever documents and other pieces of evidence that may be
If
needed.
and when the case reach the courts.
If and when the case reaches the courts.
But there are
or the
many
cases-
instances that the cases do not reach the court. And the subpoena powers here pertain to case buildup.
Then the person, the subject of the subpoena should demand the return of the pieces of evidence confiscated or submitted to the issuing authority.
Is there a specific law or regulation that explicitly provides for that?
There is
for that
none,
particular
Mr.
remedy?
There is none, Mr. President.
And
But as a
from-
matter of course, what would the director CIDG or any unit of the CIDG make use of those documents and other pieces of evidence if they are not needed for any prosecution or any litigation, Mr. President?
But the CIDG, or for that matter, any other investigative body would not, as a matter of course, do such an initiative of returning documents secured or acquired through the issuance of subpoena, which are no longer needed for purposes of cases in court.
It's not explicitly stated, but as a matter of course, they should return those documents because those documents are useless to the issuing authority, the subpoena issuing authority, Mr. President.
And there is no need to put that
Well,
in the bill.
I'm open to even inputting that into the bill as we discussed, Mr. President.
That should be all. Thank you.
Thank you,
for the
Mr.
clear-
President.
For the clear responses from the good sponsor. Thank you.
Majority Leader.
Mr. President,
Senator Gordon is raising his hand.
yes, the Minority Leader will interpolate on Monday, Mr. President, as to inform Senator Lacson. At this point, I'd like to recognize Senator Senator Richard Gordon.
Senator Gordon is recognized for interpellation.
Thank you, thank you. Well, my good friend, the gentleman from Cavite, yield to what appears to be Senator Subiri.
To the gentleman from Bukidnon. Sorry, Zambales. Olonga po, Zambales.
Thank you. Thank you. I think we needed that comic relief. We've been so tense lately. I have nothing against the proposal. I just wanted to make sure that we know where we're headed, Mr. President. So let me ask the good sponsor, what brought this about? Because in the past, as you stated earlier, as the gentleman said earlier, you had the power under the martial law regime for them to call. My concern really is the lawyers. You need lawyers. This is a form of mode of discovery.
Yes,
Uh,
Mr. President.
And to my mind, a crime committed
How many?
must immediately be addressed. If it is not addressed immediately, then you go into the situation where you have to ask for subpoenas and subpoena duces tecum. Because kung mabagal ang investigasyon po, makakaalpas eh. Kaya hahabol ka na ngayon doon sa mga subpoena, modes of discovery. So, ang worry ko, I remember we had a dialogue with some of the PNP officers, and they said they needed 72,000 investigators.
Yeah, I remember that, Mr. President.
They're short, no? And ako, I will support the police because we have to discover, we have to do all these things. Pero my only concern is not abuse, but capability. Capability. I would like to make sure and get some assurance that the PNP officers who are going to use this, the CIDG, in your case, and the PNP
Not
Director General.
not just capability, but capacity, Mr. President.
Well, capacity and capability. Capacity and capability, because they can easily throw out subpoenas left and right, waste the time of the many people that they want to admit, they want to call in, and this would create some wrinkle again within the PNP image. And that is what I want to be assured of. Are we doing anything later on? I mean, I think this should be part of a whole. When we give powers to the police, we must be assured that they are provided with the wherewithal, such as lawyers who can investigate, because the NBI has this power. And even us here, in our committee hearings, we cannot just issue a subpoena without going through the Senate President. And when you give this power to the police, and they're not lawyers, then baka, I don't want to say abuse, but I want to be sure that it will be used effectively. Positive.
They have a legal division that they consult each time they issue subpoena, or if and when they're given these subpoena powers, they will have to consult with their legal division. By the way, Mr. President, according to the CIDG officer here, there are only 4 lawyers in the entire criminal investigation and detection group. But they undergo regular training, specialized training in investigation.
That must be one of the most stressful tasks in the PNP. With all the crimes being committed, you have 4 lawyers. That is really a daunting challenge indeed. That is why you will recall, Mr. President, when that information was given to us, I said that we should really support the PNP by providing more investigators who are qualified, lawyers, to really assist the police force to make it really professionalized, so that you just don't issue a subpoena just on whim or caprice. I am not afraid of abuse. I think abuse can be discovered, but what is important is you make sure that you have enough lawyers who can guide, because they need this, to do so. And the other thing that I'm concerned about is when you have this power, like I said, the best time to catch the crooks would be immediately after the crime is committed. And that is why people will resort to subpoenas when they have no leads, and that's the time that you will have to make sure that the 4 lawyers give them the right advice and the right questions.
That is correct. I agree, Mr. President.
So, Mr. President, I think I hope that I can work with the gentleman from Cavite to make sure that in the budget next time, and I can see the minority floor leaders listening, and that we should be able to give the police forces enough investigators. Because we keep complaining, you cannot squeeze blood from stone. If they don't have the qualified investigators, they cannot solve cases. So we have to give them the wherewithal. Maybe we can't give them 72,000 overnight, but certainly 10,000 would certainly make a big difference. Or even 5,000 will certainly make a big difference. That is why it is my hope that we can all work together in concocting the budget requirements of the police early enough, and the CIDG and the PNP Director General should be able to tell us the lay of the land by which we can provide our policemen with the wherewithal so that they can effectively perform their functions in a legal manner.
I could not agree more, Mr. President, and it's most welcome that you will be partnering with us in helping the PNP raise its standards as far as investigations are concerned.
Well, Mr. President, I celebrated my father's 100th birthday today, and I remember even at that time when he was assassinated on February 20, coming year, it's going to be the 50th anniversary, we have not caught the masterminds. And I remember we were being tossed from one agency to the other. CIS, NBI, police, local police, and really it is very frustrating, and that's why I'm always very active when it comes to police work. And I think if there's anything we can succeed in this Congress, is to try and really give peace and order of a higher standard, a higher caliber. And I'm glad that the distinguished gentleman, as former PNP Director General himself, will lead the charge here, and I will offer my support on that matter, and I hope the Senate will as well. Thank you, Mr. President.
Thank you, Mr. President.
Majority Leader.
I move to suspend consideration of Senate Bill 1239 until Monday.
Any objection? There being none, consideration of Senate Bill number 1239 is hereby suspended.
Ano? Yeah, okay. Sige.
Minute suspension.